G'day, I'm Roy Thomas from Sutton Group, Professional Realty and Halifax SeniorLiving.ca. We're here today with Lola Doucet from Waterfront Law, and we're going to talk about wills. All right, Lola, so as you know, most of my clients are seniors, and some of them I found don't have wills. So let's start with the first obvious question. Why should someone have a will?
So a will is something that basically identifies what your wishes are when you're no longer around to tell people what they are. So it's your ability to have control over how your stuff is being taken care of, or if you wanted an item to go to a certain person or certain people to be taken care of. So it actually takes care of your wishes after you are no longer with us.
Okay. So Lola, what happens if someone dies without a will? I know it's called dying intestate, but what actually happens to their possessions and their stuff and their assets if they die without a will?
So basically there is a statute called the Intestacy Act, and it follows a formula of people who are entitled to your estate. So it typically goes, your spouse is entitled to the first $50,000 of your estate or the matrimonial home, and then you have your heirs, children, mothers, fathers, siblings, aunts, uncles. It goes down a list, and it's actually identified in that act. And so once that matrimonial home is gone, or the first $50,000, then your estate would be divided equally amongst the remaining heirs.
So in other words, their assets could be split up in a way that they actually don't want them split up, or people could
definitely
be getting less or more than they actually want them to.
And it's a little bit more complicated because you have to identify that you have to prove to the court that there hasn't been a will, and they have to go through a little bit more rigorous process to actually open probate, and it could take a little bit longer.
So it's going to cost more for the people to actually get the estate finalized.
Potentially. And like I said, you have no real control over what happens to your estate.
So if someone wanted to get a will, what's the process you would do?
Well, first off, I'd say contact a lawyer. A lot of people like to use will kits. I don't recommend those because everybody that I end up working with, they spend a good hour with me discussing what to put in their will. And each individual person is different. It's not a cookie cutter situation. I could meet two people with very similar situations, but they have two entirely different desires. So lawyers are sort of trained to identify these things and then to move through the process and choose clauses that would benefit them and take care of their needs.
So they're getting the advantage of your legal expertise in setting up their will.
Yes, and we see a lot of things, so we're able to make suggestions that you may not have even thought of. For one instance is like life interest in a property. Some people want their property, they may not be with no longer with the parent of their children. They're with a new partner later in life, and they want that person to be able to continue living in the home until they pass or no longer want it. But they still want their children to get the benefits of the house. So you can take care of that by giving a life interest, but somebody may not think about that off the top of their head.
Great point, great point. Now I know in a will you have to have an executor. What exactly is an executor?
So the executor is the person who actually takes care of paying the bills, filing the documents, filing final income tax returns, dividing up the property, basically managing the affairs of the estate.
Okay.
So it's somebody you should trust, definitely.
Is there any suggestions of who you should or shouldn't pick for an executor?
I would recommend that the person should be good with money, finances, reliable, and somebody that, like I said, trusts and understands your needs, or the person that you are. Because they're basically going to be taking care of your wishes. And they should hopefully be able to work or manage the rest of the heirs. So if you have a relationship that's contentious between the executor and the heirs, that can be problematic as well. So somebody who can be diplomatic is probably a benefit.
Okay, now what about, can you put funeral arrangements in a will as to what you wish to happen for your funeral?
So I don't recommend that myself personally. Typically, people are not running to sit with me to read the will before the funeral. It's not just, in Nova Scotia definitely is not the standard. I have run across situations where people have fully paid for a cremation and their family has buried them and they didn't let them know that they had paid for a cremation, and they left it in the will and they had no idea until after the fact, and they couldn't get their money back.
That's kind of...
It's a little problematic.
Yeah, exactly. Suppose somebody already has a will in place. Is there anything that invalidates that will?
Marriage. Actually, marriage will invalidate a will.
So if someone gets remarried, their old will is no longer any good?
Exactly. However, divorce does not invalidate a will.
That's a good point to mention.
So, and intestacy as well. If you don't have a will and you're not divorced, you're separated, that person who is your spouse is still entitled to the same benefits if you don't have a will and haven't identified that you don't want to include them.
So Lola, is there anything else that you think people should know? Any other points you want to mention?
I would say make sure that the people that are interested in the will, like your executor, know where it is. And sometimes I recommend give them a copy. If they are somebody that you trust with managing the estate, then it's probably not a problem for them to see the will in advance. Sometimes people like to keep that secret. Unless, of course, you think that you might be changing that executor. But I usually would recommend letting them know where it is. So if it's in the safety deposit box or a fire retardant box, just let them know so that they can access it if they need it.
All right, now if someone wanted to get a will done, I understand you had a special you wanted to mention?
Well, I do. I actually have a couples package whereby you get a will and two wills, 2 power of attorneys, and we offer a deal for that. I think at the end of the day you get a free power of attorney out of the mix.
Excellent, that's great. We are going to be shooting another video on power of attorney, so we'll put a link down below in this one for that. So if you look down below in the notes, you'll see the link to the power of attorney, so you can watch that video as well. Lola, if someone did want to get a hold of you to get a will and or a power of attorney done, how would be the best way to get a hold of you?
I would recommend either calling my office at 902-832-5126 or drop me a line by email, lola.doucet@ns.simpatico.ca.
Fantastic, that's great. Thanks very much. Thanks for watching. Please don't forget to like the video and click on the subscribe button so you'll be notified of all future videos that we do. Thanks very much for watching and have yourself a great day.